motion hearings. Let me begin as usual by asking those listening, is there any counsel that has a conflicting court appearance that needs to be called earlier? Anybody in that category? All right, if not, well, let's start with the 9 o'clock matters. Mr. Day, if you're listening, what matter do you have?
Morning, Judge. I have Haley Richardson, case 11, 2020 CF 1050.
Okay. This is
The motion
to early terminate probation.
Correct, Your Honor. She was placed on probation October 23rd of 2020 for 1 year. She has successfully completed all the terms and conditions of probation, and we're asking the court to terminate.
Let's see, Mr. Ashby, any objection? Ratings?
Your Honor, the state's only objection is I spoke with probation. It does appear that she does owe cost of supervision fees for the month of June. Those are in the amount of $54. So that would be the state's only objection.
Mr. Day, any response?
I don't have any issue with that, Judge. If that's the case, I'd ask the court just to execute the order that upon payment of the $55, I'll put that in the order and I'll have her pay it today.
Any other clarifications, Mr. Ashby?
Nothing from the state.
So it looks like she is about at 7 or 8 months of this. Is that correct, Mr. Day?
Yes, sir.
On a 1-year term. All of the other special conditions were satisfied?
They are, Your Honor.
Okay. Then Mr. Day, to prepare an order, the motion is granted contingent upon payment of the amounts owed.
Yes, Your Honor.
And the clerk have any issue with that? No. All right, Mr. Day, to submit the order.
Thank you.
Any others, Mr. Day?
No, Your Honor. That's all at the 9.
All right, Mr. Linares, what matter do you have at 9?
Good morning, Judge. Case number 20 CF 960. The defendant is Rafael Homaron Del Valle. And it's a motion for early termination of probation. Mr. Del Valle was placed on 12 months of state probation on November 24, 2020. We are at beyond the 6-month period. He has completed all terms and conditions per his probation officer. I don't believe that there is anything outstanding. So we're asking respectfully for his state probation to be terminated early, Judge.
Back to Mr. Ashby.
Point, Your Honor, no objection. I have spoken with probation. He has completed all terms and conditions.
No Bean County issues on this one?
None on this issue. None on this one.
All right. Motion is granted. Mr. Linares to submit a proposed order.
Will do, Judge. Thank you very much. Have a great day.
Bye. Let me ask any other counsel that has a 9 o'clock matter that needs to be heard next. What about Kyle Stublin?
Judge, I'm here on behalf of the Office of Statewide Prosecution. We had Luis Rodriguez for a status today. I don't see Mr. Hanukkah in, but I think we did get a future court date set.
Okay, do you want to wait a few moments and see if he connects, or?
I'll wait and see if he shows up.
All right.
He might not have, because we had the future court date set.
Yeah, I did not, this is a competency issue, and I did not see an expert report filed yet.
This is the one where we set it, he wanted to set it for hearing because of the potential language barrier issues. So he and Mr. Pica, I think, got together and did schedule another date. This was just to make sure that we got that date.
Okay, does the clerk show another date on the Rodriguez case upcoming? We'll have her check on that. In the meantime, let me address the Alexis case. That's Mr. Khalil and Mr. Ashby, 19 CF 2205, competency status. I did not see an expert report filed on this one yet.
Your Honor, we have received that. I can forward that to your office. Dr. Nelson did find Mr. Alexis competent. However, her decision was guarded. I spoke to Mr. Ashby about this case, and the defense is going to be requesting a second doctor. We can forward that order and the report to your office.
Mr. Ashby.
No objection to the request, Your Honor.
So who is requesting the second evaluation?
The defense, Your Honor.
All right, then that is granted. Mr. Khalil submit an order for appointment. We need a new control date for a competency status.
Yes, Your Honor.
One moment.
That's Manalich's office.
Melissa, on the Alexis case, 19 CF 2205, Mr. Khalil will be submitting an order for a second competency evaluator.
Okay.
We also need a status date approximately 45 days out, I would assume, counsel,
Yes, Your Honor.
for a competency status only. So that would be 10 minutes. When would you suggest?
Okay, hold on 1 second.
Meanwhile, back to the Rodriguez case, Madam Clerk, did you find an updated control date on that? So, Mr. Stubblin, it doesn't look like the clerk shows another date yet.
Okay.
I'm gonna have Melissa, I'm also gonna have you reach out while we're in session here. If you could reach out to Mr. Hanukkah's office, see if he can connect on the Rodriguez case that was set at 9.
I sent him an email. I'll try to call him as well.
All right, thank you. Melissa, anything on Alexis?
No, I just had to get into the calendar now.
Okay. Mr. Frazier and Mr. Nagel have the Andino cases, 19 CF 1443 and 2254. Will somebody be appearing on behalf of Mr. Frazier?
Yes, Your Honor. Brian Ashby on behalf of the state.
And Mr. Nagel is connected. Hello.
Yes, Judge. We just reset this for July 12th per your office.
Okay, so that's for a updated competency status?
Yes.
I did not see a report in the file.
That was the whole issue, was that we had not heard from DCF, and that was the drawback. Now it seems that DCF has gotten there's been communication through them with the doctor, and it's proceeding at that point. That's why I believe your office picked the July 12th date at that point.
Melissa, do we confirm that for the Andino cases, we have it set for a competency status July 12th?
I have a notice to that effect from your office, Your Honor. It was sent out, if you'll give me 1 second. It was sent out on, I believe, Friday. It was sent out Friday at 10:45. Confirmation number 365.
That's 12 at 9 o'clock.
Okay, that is confirmed. Mr. Ashby, anything else on Andino?
No, Your Honor.
Anything else on that one, Mr. Nagel?
Not today, Your Honor.
Okay, it's been reset. Melissa, back to which one are we looking at? Rodriguez? Or was it Alexis?
Alexis.
Okay, do you
July
have,
26th at 10 o'clock.
is that acceptable to both sides? July 26th, 10 o'clock for competency status?
Yes, Your Honor. That works for the defense.
That works for the state, Your Honor.
And in the meantime, the second evaluation order to be submitted by the defense.
Thank you, Your Honor.
All right, next, Ms. Mason for the state. Mr. Bergeramo is listed for the defense. I don't see Mr. Bergeramo connected on Cardenas.
He's down in another court.
All right, so he's reported in another courtroom, so I'll recall that. We're trying to reach Mr. Hanukkah. We have at 9 o'clock also the Minquette duel of cases, 20 CF 1000. Actually, it's two motions, one for early termination of supervision, one for return of property. Mr. Gordon for the defense, Mr. Ashby for the state.
Yes, Judge, good morning.
Mr. Ashby, do you oppose these motions?
No, Your Honor. I've received confirmation from the probation officer this morning. They have no objection to the motion for early termination of probation. As far as the motion return of property, I've spoken with Clark County Sheriff's Office. State would defer to the court on the return of property. I would state that the Commander Williams of the Clark County Sheriff's Office, they had no objection to the motion.
So on the motion for early termination, it was 12 months supervision effective from October 20th of 20. And apparently all conditions are satisfied, Mr. Gordon?
Yes, Judge.
And the state does not oppose?
No, Your Honor.
So that is granted Mr. Gordon to submit an order.
Yes.
With regard to the motion for return of property, This is for One Century Arms Incorporated semi-automatic pistol, serial number listed in 3 9mm magazines.
Correct, Judge.
Mr. Ashby, this does not have any evidentiary value at this time?
One moment, Your Honor. I don't believe so. Just want to double check the file. But from what I recall it did not.
The sheriff's office, were they noticed? Do they have a position on this?
They were not noticed in the motion. I did reach out to them, and I have communications with their legal and specifically Commander Williams from the sheriff's office. And their response to me was that they had no objection to the return of property, as the defendant currently does not have the anything legally preventing him from possessing a firearm, as far as like RPOs or things of that nature.
Is there any issues as far as the ownership of the firearm, Mr. Gordon?
No, Judge. These were his. He has a permit for them. I put on the proposed order to Mr. Ashby that the sheriff's office can object within 10 days of you signing it, because we had done that before. So I did put that in the proposed order if you want me to keep that in there as well.
My only concern is, well, first of all, the state is agreeing or deferring to the court?
The state is deferring to the court.
Is there any reason the state is not agreeing?
Yeah, it is a firearm. And in looking at it,
my only concern
with
is
narcotics as well.
My only concern is the probable cause affidavit alleges that when interviewed at the time that he was detained, the defendant allegedly stated that he carries firearms for protection from the drug dealers he engages with. Why is that not an ongoing concern?
Well, Judge, I mean, usually when we look at these return of property cases, we want them to relate to the actual charge. I mean, this is a fleeing and eluding case. This was something that he had in his glove compartment. It wasn't, it wasn't floating around the car. He wasn't waving it. They asked if he had any guns. He admitted to it. He does have a permit to carry that. Like I said, it really has nothing to do with the case itself.
Well, there is a permit.
Yeah.
He is permitted for this?
Yes. Yeah. If there was an issue with that, there would have been something additional, I'm sure. But now he does have a permit for this. Again, there's no causal relation to the charge. The original charge was fleeing and eluding, which was reduced.
Mr. Ashby, any additional comments?
Nothing from the state, Your Honor.
All right, given the totality of what has been discussed, the motion is granted. Mr. Gordon to submit an order to that effect.
Yes,
Both
Judge.
motions are approved.
Thank you, Judge.
All right, and I see Mr. Hanukkah is now connected. Mr. Hanukkah, can you hear us?
Good morning, Your Honor.
It's like you're at federal court. Did I guess right?
Yes, I can hear you.
Yeah, I'm not going to get you in trouble there with their rules because you're on a device in the lobby, are you?
Yes, I'm outside of the courtroom, Your Honor.
Okay.
We're allowed without a mask inside the courthouse.
Okay, and they allow you to be on a device at that location?
Yes.
Okay, all right, very good. So Mr. Steuben is connected for statewide prosecutor. This is the Rodriguez case 04 CF 3474, letter B. I did not see an expert report in the file. Any updates from counsel?
Your Honor, we are trying to schedule an in-person hearing. We've been going back and forth on dates. The last two dates that were proposed were August 16th and August 30th, both dates which work for the defense, and as well as Ms. Nelson, Dr. Nelson.
So has there been a report filed by the expert?
Yes, Your Honor. She had filed a supplemental report saying that he was feigning, and I had some issues because she used an interpreter and did everything virtually during her evaluation. So the last hearing, the court thought an in-person hearing with the ability to go through those issues with the expert on the stand in front of Mr. Rodriguez would be the best course of action.
And does the state have a copy of the report?
Mr. Pica, it's Mr. Pica's case. I believe he does.
Okay. For some reason, it doesn't show. Well, let me look. Maybe it is here. No, I have the appointment order, but Madam Clerk, is there anything in the system showing an expert report from Dr. Nelson? I'm always the last to know, you know. But why would the court need one, right? All right.
We can send your office, Your Honor.
So you're trying to have an in-person hearing with testimony from the expert, is that correct?
Correct.
And we're apparently down to 2 dates?
Yes.
And are you trying to get that scheduled now? This
Yes.
time?
We were speaking with Melissa, your judicial assistant, last week. I had replied to the email and I had not heard back.
Mr. Stublin, do you dare schedule for Mr. Pica?
The last I saw, because I was on the chain of emails, was for some July dates, but Mr. Hanukkah, you're saying it's now in August?
Correct. Mr. Pica has a trial with Judge
Right.
Foster 9th that could go until the 16th. So the judicial assistant recommended we either set it that day, thinking that it may be over with by that point, or that was on the 16th, or just set it for the 30th.
Mr. Stublin, are you empowered to schedule for Mr. Pica?
I'm sure I can. I'm sure I can do that. Mr. Hanukkah?
Don't want to get you in trouble at the head of the office over.
No, thank you. Mr. Hanukkah, do you know what time it was on the 30th?
Let me connect.
Both at 9 a.m. I can go look at the email.
Okay. Yeah, there is no report filed for some reason. So let me see if I can connect
Judge
Melissa.
Manalich's office.
Hello, Melissa, calling on Rodriguez. This involves, this is 04 CF 3474. It's Mr. Stublin, will you be counsel or will Mr. Pica remain as counsel on this?
I think Mr. Pica will remain counsel. I'm looking at, I can see all of our calendars. So he does have a trial potentially the week before. I think we would be fine to set it for the 16th. I'm sure I could cover if need
So
be.
Melissa, apparently you've had some recent communication with both sides about a competency hearing in person. Now, the defendant will need to be in person. Is that right, Mr. Hanukkah?
Yes, Your Honor, with an interpreter.
With an interpreter, and you're arranging that?
Yes, Your Honor.
All right. So, Melissa, it looks like the parties are indicating that they might be able to take the August 16 date. Is
Or
that
the 16th was the trial that Mr. Pica was in, possibly.
If Mr. Hanukkah's okay doing it on the 30th, Mr. Pica doesn't have any conflicts then. So, well, he does have a conflict at 9 also in Lee County for some other hearing. So
all of those dates in August or some in July?
August.
they were August.
And Melissa, you're scheduling on my birthday, August 30? We need to talk about that. It's a national holiday.
My
birthday actually wasn't a holiday.
That's proclaimed by me.
I think it would be fine to set it for the 16th. If Mr. Pica does end up, if his trial does go the week before and continues, I'm sure I can cover on the 16th.
All right, so Melissa, the 16th is available for a competency hearing, August?
I believe it was August 16th at 3:30.
Oh, 3:30, my apologies.
Now,
Okay.
is that going to be sufficient time for an evidentiary hearing, an hour and a half?
Yes, Your Honor. I expect less than that.
I think it was I think my understanding was that Mr. Hanukkah, your concern was the language barrier. So
The what?
the language barrier was your primary concern. So I thought
Correct.
it was probably in scope.
But both sides seem to think that would fit there.
Yeah.
For the time needed.
That's fine.
All right, then we'll confirm it then, again, the date and time, Melissa.
August 16th at 3:30.
The other thing is, Melissa, both parties received a copy of the expert report, but the clerk just checked. It has not been received.
Right, I didn't receive it either.
So if you could, I think this is Dr. Nelson, is that correct, counsel?
Yes, Your Honor.
Yeah, if you could just ask her in the future when she issues the reports, of course, to provide it to the clerk for filing, is that correct? Or does it come directly to us?
They should send it to the clerk, but I will request a copy. Sometimes the doctors send it directly to me and I forward a copy to the clerk.
Okay. Any, the interpreter is being scheduled by Mr. Hanukkah. Anything else to be addressed at this time?
No, Your Honor.
Nothing from the state.
All right, all set. Thank you.
Thank you.
Mr. Verderamo is present here. Hello, Mr. Verderamo. Who is covering for Ms. Mason?
Your Honor, I am Cammie Wilson, State Attorney's Office.
All right, hello, Ms. Wilson. This is on Cardenas, 19 CF 1105. It's a competency status, and I don't show a report in the file.
Correct. If you recall, Your Honor, I believe 2 weeks ago, we had an emergency hearing, and there was a stipulation by the parties to appoint a subsequent evaluation. My client was at a facility in Tampa. He was subsequently taken into custody here. Your Honor signed an order for a subsequent evaluation with Dr. Arias last week. We're in the process of coordinating the evaluation.
So, Ms. Wilson, were you able to hear that?
Yes, Your Honor, I was.
Any state perspective?
No, Your Honor.
So what would you suggest for a status update?
Say 30 to 45 days.
So about 30 to 45 days acceptable to the state?
Yes, Your Honor.
Let's set that now.
Judge Manalich's office.
Melissa, another competency status to be scheduled. This is on Cardenas, 19 CF 1105, and approximately 30 to 45 days out, 10 minutes for status. One moment. While she's looking at that, Mr. Verderamo, do you have any 9:30s or 10s?
I have a 9:30, Your Honor.
All right, we'll address that next.
July 26th at 10 o'clock.
How does that work for everyone?
That's okay with the defense.
No objection, Your Honor.
It is set. Thank you.
Okay.
Mr. Verderamo, which one do you have next?
Antonio Andretti, 20 CF 263 with Mr. Ashby.
All right.
For early termination of probation.
All right, Mr. Ashby, any objection?
No objection, Your Honor.
Court will review the motion indicating placed on supervision October of 2020. Charges are not of particular concern. 12-month supervision. No issues of any compliance with monetary or other conditions.
No, he's more than halfway, and there's been no violations during the duration of supervision.
Madam Clerk, any monetary amounts showing outstanding? Motion is granted. Defense to submit a proposed order.
I have an order right there.
Thank you. I will review the order. Does the state, it just says basically probation's terminated. Is that acceptable, Mr. Ashby?
Yes, Your Honor.
Okay.
Thank you, Your Honor. Have a nice day.
Okay, very well. Court is signing the order at this time and filing with the clerk. All right, next, and that was on which one, Madam Clerk? Andrade, okay, very well. All right, let me just ask of counsel that are connected either for the state or defense, is there anyone that has a conflicting court appearance that needs to be called sooner? If not, we venture into the 9:30 hour. Rakowski, 16 CF 1539, Mr. Samato and Mr. Day. I don't see Mr. Samato yet though. And we are actually Swiss time would say we're 3 minutes early. So we'll recall that. Next is the Fisher case listing Mr. Fraser for the state, Mr. Barger for the defense, 21 CF 100B. It's a motion to lift the no contact order. Is there any objection from the state to addressing it in this format?
No objection from the state, Your Honor. And I've spoken with Mr. Frazier. He has no objection to the motion as well.
All right, Mr. Barger, any clarifications needed?
Your Honor, Mr. Williams did file a Nelson inquiry or a Nelson hearing, request for Nelson hearing, and I didn't know if you wanted to address that first or not.
Is he connected at this time?
He is in custody, Your Honor.
All right, he would not be available at this time, I believe. Is that correct, Officer Harrison?
It would take some time to get him over here.
Okay, was that was not something that was scheduled, is that correct?
It was not, Your Honor. Melissa tried to schedule it for next month sometimes on a different case. However, we had this here today. I didn't know if the state wanted to address it, and and go forward with it first or not?
Well, obviously, I think that strictly, technically speaking, we would have to address the Nelson hearing before this motion, would we not?
I would be willing to handle this motion first, Your Honor, and then do the Nelson hearing. It does address this motion within the Nelson hearing or Nelson inquiry.
And I haven't seen that motion, but as part of his reason for requesting the appointment of new counsel, his frustration with not getting the no contact order lifted?
Yes, Your Honor, it was.
Were there other grounds alleged?
There were other grounds alleged, yes, Your Honor.
Then I think what we'll do, we'll go ahead, since it is consistent with the Nelson hearing grounds, to grant this motion and the state has no objection, then I would go ahead and grant this motion.
Okay, I'll go ahead and prepare an order, Your Honor, and then I'll come down.
My thought is it may or may not affect the defendant's desire to proceed with the Nelson hearing. Plus, it is consistent with his wishes.
Yes, Your Honor.
So, and again, Mr. Ashby, no objection?
No objection, Your Honor.
So this would be, is there to be any limitations, or would this be unrestricted contact between Mr. Williams Fisher and Ms. Nikita Martin?
My understanding was it would be unlimited contact. It's for the benefit of their child. They have a baby on the way.
Is that correct, Mr. Ashby?
That is my understanding, Your Honor. They are co-defendants. So.
Well, the only reason I raised it is that paragraph 4 of the motion said that Mr. Williams Fisher would like to have contact with Ms. Martin in order to establish and coordinate child care plan. So I didn't know if the intent was to limit it just to child care issues or to just remove the no contact order in its entirety.
I would argue to remove the no contact order in its entirety, Your Honor. I think that there are so many aspects of child care that, it would be better to have them not have any restrictions at all, just to not be here again on a violation of the no contact order because, when somebody was meeting with somebody or something like that. So I would ask to have it removed altogether.
Number one, I agree that child care is complex, and I think Mr. Ashby now with his twins would probably also agree with that. And Mr. Barger, I know that you have the same issue that you are dealing with.
Yes, sir.
But the question, Mr. Ashby, from your comments earlier, I think you are not objecting to unrestricted contact. Is that right?
That's correct, Your Honor. As stated, they're co-defendants, and the state's not concerned about their contact affecting the case.
The no contact order lifted in its entirety. There are no restrictions. Mr. Barger, to submit a proposed order, and then Mr. Barger, will you then notice for hearing if necessary after speaking with Mr. Williams Fisher and informing him of this ruling, whether he wishes to have his Nelson hearing set?
Yes, Your Honor. I can also speak with Melissa about keeping the date that she'd previously set. And
okay, so we actually have a date on that motion.
I believe that she was talking with co-counsel about a date.
Okay.
I'll submit the order, Your Honor. Thank you.
This is granted. All right. Let's take a look here. I don't see Mr. Simato yet. Is someone covering for Mr. Simato? Okay, we have silence. All right. Mr. Day, are you still monitoring?
Yes, Judge.
Yeah. As far as you know, Mr. Simato is handling the Rakoski matter.
He is, Judge, and I have hearings all the way to 10, so I'll go back on standby and I'll try to call him while you're working through the docket.
Thank you.
All right.
All right, next, I show Mr. Berry. I don't see anyone from his office appearing yet with Ms. Wilson on Columbella. That's a 10 a.m. matter, though, actually. Let me see if there's anyone. I think, Mr. Day, if you're still there, I shouldn't have let him go.
Yes, Judge.
Mr. Day, I think Ms. Wilson is also available on a 10 o'clock matter.
Sure.
And this
Sorry,
is,
which?
Greetings, 18 CF 1776, Defense Counsel's motion to withdraw.
Yes, Your Honor. On Mr. Heinze's case, the court may recall this case we've been dealing with for some period of time, but the court did issue a bench warrant in light of the fact that it appears Mr. Heinze is not in the jurisdiction anymore. So there is a pending bench warrant right now. We've had no contact with him, so we're asking the court to allow us to withdraw.
So it is unlikely that even if I called this at 10, Mr. Heinze would be appearing today?
No, Your Honor, the bench warrant was already issued during our last call.
So you are seeking to withdraw?
Yes, Your Honor.
All right. And it's on bench warrant status, so there are no future court dates.
No, Your Honor.
Ms. Wilson, do you have a comment?
Nothing from the state.
The motion is granted. Mr.
Your
Orr?
Honor, could I just inquire while we're here, Ms. Wilson, if you could email Mr. Samato?
I
I'd
will do that.
appreciate that. Yeah, I tried to call him, but there was no answer.
Okay,
All right, thank
I'll do that.
Thanks.
I do see that Mr. Hopkins has now joined us on the Columbella case, 20 CF 1228. Ms. Wilson for the state. Can you hear us, Mr. Hopkins?
I can. Good morning, Your Honor.
Greetings. And this is a defendant motion for return of property. Does the state have a comment initially?
Your Honor, I did contact the Collier County Sheriff's Office and they had no objection. And looking at the case, this is one that was resolved at the early resolution docket. But I did look over, it looks like the defendant told law enforcement about the gun when contact was made. He has a concealed permit. He's not a convicted felon. And it was not a requirement of the plea for him to surrender the gun. State would defer to the court.
So it appears that the request is for a 38 caliber Smith & Wesson revolver, serial number identified, 5 rounds of similar ammunition, and a holster.
Correct.
By the way, the holster name seems to have a name that could be perceived as racially derogatory, so I did not mention it. I'm not sure if I'm misinterpreting that description, but regardless, I'll just say holster. Mr. Hopkins, any clarifications on the property or the motion?
No, Your Honor, I would just ask the motion to be granted. The only thing additional that I would add is that Your Honor granted his request for termination of probation in late May. It would be like mid to late May. So I don't show that he has any prohibition for the actual possession of the items.
There is no question as to ownership?
No, correct.
Okay. Ms. Wilson, any clarifications?
No, Your Honor.
Motion is granted. And by the way, the sheriff's office did not have any comment on this?
Your Honor, I heard back from both the detective on the case and the arresting officer, and both of them said they had no objection.
Motion is granted. Mr. Hopkins to submit an order for the return of property.
Yes, Your Honor.
All right, let's see who else we have. We're still waiting for Mr. Samato.
Judge, we could do the 1030 Moss matter. Ms. Wilson is here.
Sure. Sorry, it's Laughlin?
Moss, Your Honor, 20-1334 CF.
Yeah, that's a competency status review 1030.
Yes.
What is the status?
You signed in the order. I believe the court had an order signing it, transporting him back here based on the findings at the hospital that Mr. Moss is now competent to proceed. And based on the reports at this point, I have no reason to believe there's any concerns at this moment.
So it has been recommended that he be found competent to proceed.
That is correct, Your Honor.
And does either side wish to have an evidentiary hearing?
No, Judge, not at this time.
Okay.
At the front state.
Are the parties agreeing that the court may rely on the report to enter a written order of competency?
Yes, Judge.
Have you had any interaction with him since his return, Mr. Nagel?
I played phone tag with, actually, while he was being prepped to be returned, The facility called me on several occasions. I ended up playing phone tag back and forth with the individuals, but based on a message that Mr. Moss himself left, it seemed to me like competency would not be an issue at this time, as compared to when he was originally evaluated. The conditions then do not seem to be present at this moment.
So the court will go ahead and prepare an order based on the report, and the parties are agreeing to the recommendation and not requesting evidentiary hearing. We then need to set this matter for case management, I assume?
Yes,
That
Your
is correct, Your Honor.
Okay, how soon?
I think we have one, it's what, Thursday? I think that might be a little soon.
Agreed.
The one after that would probably be sufficient, Judge.
And clerk, we have the next, the subsequent court date. July 15, 9 a.m. suitable to both sides?
Yes, Your Honor.
Okay.
Thank you, Your Honor.
Or we'll follow up with a written order. Let's take a look at who we have and see if there's any other matters we can address ahead of time. Ms. Brown, what are you waiting for?
Your Honor, I'm here on two matters. The first is Herrera Victores 21376 CF with Mr. Day.
Mr. Day,
and then the
that?
Yes, Your Honor.
So Herrera Victores 21 CF 376.
Yes, so Your Honor, the intention of this effort this morning is Ms. Victores has a Department of Children and Family Services case pending, and they are working through the plan for reunification ultimately. And they're at the beginning processes of the plan now, and part of that will become slow reintroduction with the child for supervised visits. And they cannot move forward with that because there is a no contact order in this case. So we're simply asking that the court modify that no contact order to allow the contact to exist consistent with the dependency case number 11-2021 DP 23.
State comments.
Your Honor, Mr. Day and I spoke about this last week, and we're in agreement. I believe that Mr. Day has a proposed order that the state does not oppose the request, that it track along with the dependency case.
So, Mr. Day, sometimes in the past, this has been a chicken and the egg thing where each court is looking to the other to loosen the restrictions. So the dependency court is involved, is that correct?
That's correct. They're working with a reunification plan now. They're at the beginning stages of that. And of course, at the beginning stages, there'll be a point where the child will have supervised visits with the mother before it progresses to latter states. And they're simply trying to get to step one right now. So we need this modification to allow them to do that.
So what will this order say then?
It'll just say that the no contact order is hereby lifted consistent with the order in the dependency case 11-2021 DP 23.
And that's the language that the dependency court is looking for in order to allow the reunification process?
Correct, Your Honor.
Any other state clarifications?
No, Your Honor, it's my understanding from Ms. Cunningham that this order has the typical language that allows contact to be as directed by the dependency court.
All right, then it is approved, Mr. Day, to submit the order as discussed.
Thank you. Your Honor, the only other one I have is State versus Ralph Fetch. I believe that's with Miss Roger, and I don't see her yet. It's not set till 10.
Right. Let me take a look. I don't see Mr. Russo yet. Yeah, that's at 10 o'clock. Any word on Mr. Samato? He's usually prompt. Mr. Day, any update on reaching out to him?
No call back yet, Your Honor.
Okay. So that's Rakoski. Are you willing to hold on that, Mr. Day?
Yes, Judge. I have other motions, so I'm here.
All right. Let me take a look. So we've got Rakoski, Fetch, Laughlin. I don't see Ms. Fish yet. Lopez, maybe we can address that. Mr. Ashby's connected as well as Mr. Day, 16 CF 1560.
This is Mr. Lopez's motion to terminate probation. Mr. Lopez was placed on probation May 30th of 2017, directed to complete 4 years of state probation with other terms and conditions. We did receive confirmation from the Department of Corrections on May 24th that he has successfully completed all terms and conditions, and probation had no objection with the termination. From Officer Stephen Law out of the Fort Myers office.
Apparently sentenced May 30th of 17, 18 months state prison followed by 4 years state probation. So how far does that put him into the state probation term?
Your Honor, let's see, he was released March, hold on a second. He was released from custody on March 6th of 2018. So he's beyond his halfway point.
Okay. All conditions, including restitution, paid?
Yes, Your Honor.
State have any comment or concerns?
No, Your Honor, I did speak with probation. In this case, they did say that the defendant had completed the terms and had paid restitution. The only issue was that there was the cost of supervision for the month of June that was outstanding.
And that is still outstanding?
That was outstanding as of this morning from when I spoke to probation. It was $54.
So, Mr. Day, the court will approve the motion contingent upon payment of the final probation costs and fees.
Yes, Your Honor.
State defense to submit the order.
I will.
Okay, next we go to, let's see if we have anybody else. Mr. Barger, what are you waiting for? If you're still there with us.
I am, Your Honor. Nothing. I was just finishing that order and hadn't disconnected.
All right. I don't see Mr. Ward yet. He has a 10:30.
I'll let him know. Thank you.
If he's available, we could address the 10:30 now. Anything else I can address for the state or Mr. Day, who appear to be the only ones waiting right now? Looks like the others were well ahead of schedule. Looks like the others just a little bit later. So at this point, let me give it a moment, see if Mr. Ward might be available. We could take care of the Wilson case. Ironically enough, Ms. Wilson, state's counsel on that.
I just texted Mr. Ward.
Your Honor, Mr. Ward is going to be connecting right now. Just give him a few minutes.
Wilson, are you still monitoring?
Yes, Your Honor, I am.
All right, and we have, ironically enough, the Wilson case.
No relation.
20 CF 1835, awaiting Mr. Ward, who should be connecting momentarily on a motion to compel. I'm reminded of the soccer ball, I think, that Tom Hanks named Wilson in the movie.
Yep.
Masterful performance. Hard to believe you could spend an entire movie watching someone talk to a soccer ball. But good dramatization by the actor. Hello, Mr. Ward. Are you connected?
Yes, Your Honor.
All right, we have the Wilson case, motion to compel. Does the state oppose this motion?
Yes, Your Honor.
Argument or evidence from the defense?
Your Honor, the alleged victim in this case is out on, he's on county probation. The address given by the state is general delivery. Obviously, I can't subpoena someone for deposition at a general delivery address. This is substantially disrupting the defense's preparation in this case for trial. I'd ask the court to compel the state to provide a better address within a reasonable time frame.
This individual is the alleged victim?
Yes, Your Honor.
Ms. Wilson, what's a defense lawyer to do?
Your Honor, the victim is homeless, and even though he is on state probation, he's homeless, so there is no better address for him. And despite what's in the motion, I did respond before the filing of the motion by 3 days, letting Mr. Ward know that I had contacted probation. That was the best address we have. And under the rule, the state's required to disclose to the defendant any information or material within the state's possession or control. At this point, we do not have possession or control of his address. So at this point, perhaps Mr. Ward can have his investigator see if he can locate him, but we do not have a better address for him.
Does the state know if the individual is in good standing with probation and reporting?
Your Honor, my understanding is in the last contact was the fact that he had not shown up for probation, and I believe they were going to put out a warrant for him for a violation of probation. So at some point, obviously, if he gets picked up, we'll have an address at the jail, but currently we do not have an address for him other than general delivery.
Mr. Ward, response?
Judge, I wasn't, well, I would refute the state's claim that they responded to me prior to the filing of the motion. It doesn't really matter for purposes of the motion, but I just don't want to indicate that I filed something incorrectly. But regardless, Your Honor, I'm not aware of his violation status. If he is in violation status, that's one thing, but if he's not, he reports once a month. The state could give me his reporting date and time, and I can try to subpoena him at that time, but they haven't provided that.
And it was not requested, Your Honor, and I do have a copy of the email that I did send out to Mr. Ward on May 17th. I don't know if there's an issue with him getting it, but I do have a copy of it. But regardless, Your Honor, at this point, we do not have it. We can't be compelled to give something that is not in our possession. And as soon as we know, Mr. Ward will know.
So, Ms. Wilson, the information provided by the state up till this point says what?
Is that we have an address of general delivery, which is, he was in the jail. This is a case in which the crime occurred to the victim while we were in jail by a battery by a person detained. Since that time, he resolved his misdemeanor probation case there, and he was placed on probation. So at this point, probation says he's homeless, but they have put a warrant out for him.
Well, I understand the state's point that I think the state in good faith does not have a specific address.
Correct.
On the other hand, to say general delivery does not provide the defense any meaningful way to attempt to subpoena this individual. What I'm inclined to do, but I will hear other comments of counsel, is to grant the motion in part to the extent that the state will be compelled to update any additional new addresses that it may be informed of through probation or other means if they come into existence.
Of course, Your Honor, as soon as we get a new address for him, we would just naturally update and do an amended witness list.
So if you would put in the order, Mr. Ward, that the motion is granted in part, you can put in there that the court finds the state has, in good faith, provided the only known information for the defendant so far, but the state is ordered to have an ongoing duty to update the defense with any new information about his whereabouts if it is obtained from any source, including probation.
Yes, Your Honor. Can we also include an obligation to inform of his reporting date and time if he's still reporting?
Your Honor, I would argue that we're not obligated to do something that the defendant himself can do. And in this case, Mr. Ward can call down to state probation and ask for the date that he's due. But at this point, there's a warrant because he's not showing up. So at this point.
Ms. Wilson, will probation provide that information to the defense?
I would think so, but also if they looked up into the probation case for the defendant, which I can provide, which I believe is 18 CT 2900. If there's a warrant out and in the clerk's file, then it would have the allegations as to what date he was supposed to report and did not report.
Well, I think Mr. Ward is talking about future reporting dates.
Right, but at this point, that would only occur after he's been picked up because he hasn't shown up.
There's always the possibility that he might show up at probation despite a warrant. He may not even be aware of a warrant at this point, but as long as you believe, Ms. Wilson, that probation will answer the defense's inquiry about his upcoming reporting dates, then at this point, I will not include that in the order. However, Mr. Ward, if probation refuses to disclose that to you, future reporting dates, then I would consider adding that to the order.
And if he will not give it to Mr. Ward, if he'll just let me know, I'll be glad to reach out to them again.
All right, so the motion is granted in part, and Mr. Ward to submit the order.
Thank you, Your Honor.
All right. I saw Mr. Samato. I had a glimpse of him.
Good morning, Your Honor. Tino Samato on behalf of the state.
Greetings. And we were calling on the Rakoski case.
Yeah, I apologize for my tardiness, Your Honor. I was unaware of this hearing. I know it was noticed, but I didn't get the notice.
Okay, no problem. 16 CF 1539. Mr. Day for the defense. This is a motion to modify supervision.
Correct, Your Honor. The defendant is well into the probation that was imposed in this case. She has a job that takes her, she's in the agricultural industry. She has a job that's taking her out of state for the watermelon season. Probation contacted me and advised that they do not have an issue with her doing that as long as she follows their rules. However, they would like a court order indicating that you have no objection to her traveling for that purposes. She's already attached to the motion is the work information as to when she'll be going for the season. Probation's in receipt of that. She'll be glad to comply with the probation rules. We just simply are requesting the court to grant an order allowing her to travel for business purposes only.
And this is specific to watermelon season.
That's correct, Your Honor.
I didn't realize that had a recognized season.
It does, yes.
Well, I understand she works for Gulf Shore Produce. I didn't realize she specialized in the watermelon trade.
That's the purpose of her travel out of the country for that season, or out of the state, I'm sorry, for that season.
Okay, Mr. Samato, your reaction to all of this?
Well, I'll be looking forward to the sales at Publix. And it looks like there's a 5-week period that's articulated.
Usually buy the whole melon, Mr. Samato, or the sliced version?
He buys the sliced version, Judge.
Sliced. I can't carry a whole watermelon, let's be honest.
Mr. Gallops, Judge, Mr. Gallops has been known to walk into the courthouse carrying 4 or 5 watermelons and giving them away, but that was in the old days.
Well, who was our Edgerrin James says that's how he got so strong. He said working the watermelon trucks.
Absolutely.
But anyway, I digress. Sorry, Mr. Samato.
It's okay, Judge. It looks like there's a 5-week period articulated in the letter that was attached to the motion, Judge. My only request is that the court order that she reports somehow, either by phone or however the probation feels appropriate. But I don't have an objection to her traveling for that 5-week period. And I think it would be appropriate that she report before and after she leaves. She leaves and when she comes back, I should say.
Yeah, I will say, Judge, I talked to Russell Holton. There's a whole procedure she still has to follow. She has to get her travel approved ahead of time. She has to send the schedule. She has to still report, and she still has to fulfill all the other obligations. So she's absolutely going to do all of those things.
So the court will approve the motion, the order to include that Ms. Rakoski to comply with all probation requirements related to travel, including reporting both before and after the travel. Is that correct, Mr. Samato?
Yes, Judge, I think that would be appropriate. I think she would normally report anyway prior to the June 9th date. I think the sticking point would be that she would probably report before the July 16th return date. And so I think it would be appropriate somehow to report either by phone or however during the course of her leave to probation.
So the language would be that she report either in person or remotely before, after her return within 48 hours on each end?
I think that's appropriate, Judge. I also think she could report remotely, either by Zoom or by phone, during her 5-week departure.
So as directed by probation on that part of it?
Yes, if probation finds it's appropriate, I think that would be appropriate.
So Mr. Day, it looks like what we're down to is defendant, it's approved to follow all probation requirements regarding travel, including also required to report either in person or remotely as coordinated with probation 48 hours before, during, as directed by probation during the term of travel, and within 48 hours of return.
I'll have that in the order, Your Honor.
Okay, any other clarification, Mr. Samato?
No, I think that's appropriate, Judge. Thank you.
Approved, thank you. I see that Ms. Fish has now joined us. Sorry. Hello, Ms. Fish.
Good morning.
And this is on the Laughlin matter. Is anyone covering for Ms. Mason?
Yes, Your Honor, I am.
Ms. Wilson, 19 CF 297, motion for early termination of supervision. Does the state oppose the motion?
Yes, Your Honor, we do object to the early termination of probation. He was placed on probation on February 18, 2020 for 2 years. However, he owes $955.12 for supervision fees. He's paid everything else and even received a refund from the clerk's office for over payment of some fees, but he didn't transfer that to pay the supervision fees. So we're requesting that he pay the supervision fees before he gets terminated early.
And you said these are rather substantial. Were they, you said $900?
$955.12 is what Mrs. Mason has here.
Does the state have any objection if the court were to grant the motion contingent upon the prior payment in full of all supervision costs and fees?
Not that I'm aware of, Your Honor. She did not address that with me. She just stated that she objected because he had outstanding fees.
Ms. Fish, comments?
Your Honor, I do apologize. I thought that we had paid those fees, but we will pay them even today. That's possible. We would request that you allow for us to do this early termination contingent to us paying within the next day or two.
I'm assuming that given the nature of the charge, aggravated assault, deadly weapon, that there was a no contact order in place. That is no longer a concern for the state or probation, is that correct? They would disappear, obviously, upon granting this motion.
Nothing was mentioned, Your Honor, about that.
So the court will approve the motion based on the representation that all conditions have been met, except for the payment of supervision fees and costs. So the motion is granted contingent upon the prior payment in full of all remaining monetary amounts.
Thank you, Your Honor. We will pay that and then submit a proposed order.
I see Mr. Russo has now joined us. And Mr. Russo is here on, let's see, which one is it?
It's Mr. De Leon Lucas.
There we go. 21 CF 475, Ms. Mason or Ms. Wilson covering for the state?
Yes, Your Honor.
All right, this is a motion for bond reduction. Is the state amenable to addressing it in this format?
Yes, Your Honor, and we have no objection.
So there is no objection to the reduction motion. Let me turn to that. The request appears to be to reduce to 5,000 per count. The state is agreeing to that?
Yes, Your Honor.
Any other clarifications or comments, Mr. Russo?
No, I will prepare a proposed order and send it to Ms. Wilson. It'll be 5,000 per count for a total of 10,000. And after Ms. Wilson reviews it, we'll send it off to Your Honor.
The contact order remains in place? Is that correct?
Yes, there's no change except for the bond amount.
So there's a no trespass, a no firearms, and a no contact order from first appearance, all of those will remain, but the bond amounts are reduced.
That's correct.
Yes.
Any other clarifications?
No, Your Honor.
All right, it is approved as discussed. Mr. Russo to submit the order.
Okay, thank you.
Let's take a look here. Ms. Roger, don't see her yet.
She is currently in front of Judge Adams during the plea.
All right, she's currently, I'm told, in front of Judge Adams, wrapping up a matter there. Officer Harrison, were you the impression she would be walking in then?
She'll either come in or on Zoom.
Okay. I don't show any other matters. We have gone at warp speed here today. And that is the only matter pending, I think. For the state, Ms. Brown. And you're still monitoring, Ms. Brown?
Yes, Your Honor, I am.
All right. This lone remaining matter fetch was set for 10 o'clock. And I'm told that Ms. Roger may be wrapping up.
Yes, Your Honor.
And try to get an update here.
She's currently in front of Judge Adams right now.
Right, so currently before Judge Adams. Do you want to hang on for a few more moments? Were you under the impression that it was going to be a brief matter, Officer Harrison?
She's in the middle of a plea.
So in the middle of a plea agreement?
Yes.
So, and then she was aware that we were looking for her here?
Yes.
So what do you want to do, Ms. Brown? Do you want to come back in a few minutes, or do you want to just continue to hang on?
I don't mind hanging on, Your Honor.
Okay, I'm looking, I just don't see anything else that is set for the morning except for this one.
Yes, Your Honor, I think you're right.
Okay, so let's just wait for another 5 minutes and see if we get an update. If not, we'll recess and then come back when she's available. Let's wait 5 minutes then.
Yes, Your Honor.
She should be logging on.
Okay, apparently she's going to join us remotely, I'm told. It should be momentarily.
Okay.
All right, Ms. Roger, can you hear us?
Yes, Your Honor. Can you hear me okay?
Very well. We are calling the fetch case 05 CF 1796, motion early terminate supervision. Does the state oppose this, Ms. Brown?
We do.
All right, Ms. Roger, will this be an evidentiary or argument only?
No, Your Honor. I believe I had e-filed a email from my client's probation officer. And also I had e-filed a letter from his sex offender probation therapist. Unfortunately, he's passed away since the time that he wrote the letter on behalf of my client, but I would ask the court to consider the letter from the probation officer as well as Dr. Schengberg in determining whether or not you would early terminate his probation at this time. There have been no violations.
So looking at the judgment and sentence in this case, one moment. It appears that sentencing occurred on lewd and lascivious molestation charges in looks like January perhaps of 2006, and that there was a prison sentence involved. Looks like 10 years prison followed by 10 years sex offender probation. So I'm assuming the prison term was done, Ms. Roger.
Yes, Your Honor. And he has complied with and completed the terms of his probation, and he has served half of the probationary period.
So,
and there have been no violations.
In terms of actual time spent on sex offender probation, how many years?
5
of the 10.
Yes, Your Honor.
Okay. You said that, and Ms. Brown, are you in receipt of these filings that the defense alluded to?
I am, Your Honor, yes.
Let me see what they consist of. Melanie Weaver is one of the items, is that correct, Ms. Roger?
Yes, Your Honor. She was my client's probation officer during the time of his supervision.
Okay, I'm reviewing that. It appears to say that Mr. Fetch was in compliance with the financial obligations of supervision, that he completed sex offender treatment with the experts. It goes on to say Department of Corrections does not recommend early termination, but confirms compliance with conditions and no violations, stable residence, and employment.
Yes, Your Honor. And up until the time Dr. Schengberg had passed away, my client was voluntarily going to see him just on a voluntary basis. And then unfortunately, the doctor passed away.
Now I'm looking at what you filed from Dr. Schengberg, March 1920.
Yes, Your Honor.
That's the certificate of completion of sex offender program. Okay, there's also that appears. Is there any other filing?
No, Your Honor. Do you see the certificate of completion from Dr. Schengberg?
Yes.
Okay, that and the probation officer's email are the 2 filings that I had in the file for you.
Is Fetch expected to attend this hearing today remotely or in any other way?
I didn't have him, Judge, do that. I told him I can speak on his behalf this morning.
Okay. Ms. Brown, what is the state's position?
Your Honor, the state does oppose the request. I understand that probation, and I confirmed with probation as well that Mr. Fetch is current on all of his finances. There have not been any violations. He's completed all conditions that he is required to complete. However, as the email indicates, the department does not recommend early termination. As the court can see, there are 6 counts that Mr. Fetch pled to. My records indicate Mr. Fetch was released from prison, I believe, in June of 2015. He has been on probation since then, so he's actually approaching, by my math, the 6-year mark on probation. I have spoken with the victim, who is aware of the motion and ultimately defers to the court. But Your Honor, given the number of counts, given the nature of the charges, the state would be in opposition and request that Mr. Fetch complete the 10 years of probation that he was sentenced to.
So the victim is not voicing opposition, but is deferring to the court?
He is not taking a position. The victim is now an adult.
I assume there's a no contact order as part of this?
There would have been that as a condition of probation, Your Honor, but obviously once probation expires, that will as well.
And Your Honor, just as a side note, I know the Department of Corrections never really takes a position in agreeing to the motions to early terminate. They usually stay silent on that. They just inform the court whether or not the offender is currently in compliance with the terms and conditions of probation.
Well, this correspondence, which does confirm positive information about Mr. Fetch, does, however, appear to say more than that, because it does say that the department does not recommend early termination. Do you interpret that to be?
Judge, in my experience, the Department of Corrections never recommends, ever. Their function is to just inform the court whether or not the offender is in compliance. I've not seen anyone from the Department of Corrections, at least in any of my cases, actually ever say we would agree to early termination. They always leave that up to Your Honor.
I would agree that they seem a little hesitant in that regard. On the other hand, I do see them frequently say that they do not take a position.
I understand.
Judge,
go ahead.
Because they do not recommend early termination. Now, do you think I'm misinterpreting their words there?
I don't, not necessarily, Your Honor. However, Miss Weaver, I think she's in Fort Myers, actually, and I don't know if that's maybe the way that they do things there. I wouldn't mind seeking clarification from her regarding that, if the court's more comfortable with me providing a second email that says that.
Well, I think that's pretty significant. It's not controlling, okay? But it is a significant consideration if they are specifically recommending not. It doesn't guarantee how I'm going to rule, but I think fairness to both sides, that really should be clarified, because if they are not recommending it, given that we've just reached the 5-year mark of 10,
almost 6, yes, 6 years.
Okay, but with a specific, if that is to be taken literally and they are saying we do not recommend, then I'm likely to deny this motion today. If what they meant was they don't take a position, then I would think about it further. That does not guarantee I would grant the motion, but I would.
Understood.
So
I understand, Your Honor. Can we continue the motion then, so that I can reach out to Miss Weaver once again and just make sure that we are both have an understanding of whether or not they typically say we do not agree with early, or we're not suggesting grant the motion, just for clarification.
Right. And Ms. Brown, do you have any requests in that regard?
In terms of canceling versus continuing it?
Just continuing it, yes.
I don't take a position.
So we'll just continue it.
That's fine, Your Honor.
By the defense with notice to the state, but
yeah.
Does the state have any request on any clarification to be made by the probation?
No, Your Honor. When I reached out to Ms. Weaver, her email to me indicated the same as it did to Ms. Roger, that the department does not recommend early termination. I know that I've never seen the department make that particular statement, but in truth, I haven't done many motions on sex offenders. It may very well be the language that the probation officers take on sex offenders versus someone else. So I don't have an issue with continuing it to try to clarify what DOC means by they don't recommend early termination.
Yeah, the question is, does this language literally mean they are opposed and do not recommend it, or does it mean we're not taking a position?
Yes, Your Honor.
Okay. And again, if both sides will remind me of what the purpose of the continuance was, and that regardless of what the answer will be, well, let me say this. At this point, I can say this. If the meaning of that language is that they are opposed, then I'm either going to deny it, or if you want to have an evidentiary hearing, Ms. Roger, or you would challenge that, then I would make that decision at that point.
Yes, Your Honor.
On the other hand, the meaning of the language is that they don't oppose the motion, then I'll consider it further and hear any comments before deciding.
Yes, Your Honor.
All right, very good. It'll be continued then.
Thank you.
Thank
okay,
you.
Thank you, Your Honor. That's all I have. Thank you.
I believe, Ms. Wilson, that wraps up everything. I don't think you have anything else.